Which has not expired. Don't mention which has expired. Which is yet to expire. Mention the date when it is expiring. Application not now. Please hand over the slips where interim order is yet to expire. Mention the date when it is to expire. Applications, hand over the slip. When did it expire? February. Hand over the slip. All in February. February. Hand over the slip. Please. Wait. Applications, please hand over the slip.
These are also in the list for extension. I mentioned earlier. The matter has been listed on the
When did it expire, Mr. Mahato? Applications, hand over the slip.
May I be permitted?
Any application, hand over the slip.
Section 24.
Yes.
Restoration for
Wait. The court will say from
Upgradation, hand over the slip mentioning the urgency. I am paying for. I am paying for. Upgradation, please hand over the slip mentioning the urgency. Please, madam, upgradation, please hand over the slip.
My lord,
upgradation.
my lord, may I most humbly, my lord,
Upgradation.
Please wait, upgradation, please hand over the slip. Yes, inclusion under the heading motion only. Hand over the slip.
Motion for restoration.
Restoration application, sir, I have said hand over the slip for application. At that point of time, you did not hand over. Please don't mention hearing matters. Please don't mention hearing matters.
my lord, may I have my lord's kind leave?
Correction to be mentioned for correction.
My lord. Combined is 155.
Combined is
155.
155. It may be reached in the next week. Please wait because I have reached up to, I think, 114 or 15.
My lord,
Sir, 114 it has been reached till yesterday.
my lord, my matter is urgent. My lord, kindly hear, my lord. My lord,
Urgent.
my lord, what is the urgency? I am explaining.
You may indicate that in the mentioning slip, it will be looked into.
My lord, 26th is the date fixed for delivery of
Sir,
judgment.
please mention that in the slip.
My
It did not mention.
May your lordship please, my lord, I am mentioning the matter because, my lord, under 25, the parties agreeable for the transfer. Let it
What do
appear.
you want, sir? What do you want?
Let it appear as to be mentioned so that both the parties are agreeable to the transfer. That is
Not to be mentioned. Is it appearing in the list?
It was appearing, but now, my lord, this is out of list. So it will take only 1 minute. Both the parties are ready. My lord,
All right, hand over the slip.
upgradation for settlement.
So, Banerjee, upgradation, hand over the slip. Mention that in the.
Let it appear as to be mentioned so that it will not take more than 1 minute, my lord. Because parties are ready. Parties are willing. That
Sir, you have handed over the slip.
Yes,
I will look into. I will look into the slips.
Yes, I have done.
21, my lord.
Madam, please indicate that. Please hand over the slip. I've told you to indicate the urgency.
My matter is a lot of urgency in the sense, my
Sir,
life is.
please indicate in the mentioning slip. For inclusion in the list. So I've said that hand over the slip. Please, madam, hand over the slip. If you have already handed over the last occasion, please see what has been endorsed in the mentioning slip.
Lordship,
Or expedited.
Motion, please hand over the slip.
motion ground पे दिए थे।
My lord, can you release this matter, my lord? Item number 726, 726. Can you release this matter, my lord? My lord, actually this matter, my lord, can you release this matter? 726.
Yes, sir, please hand over the slip mentioning the urgency.
Lordship, Lordship, may I be permitted to mention one thing only with your Lordship's permission, and Lordship don't take it otherwise, Lordship. Lordship, the problem is that in a CO 614 of 2025 was disposed of in favor of the petitioner without serving the copy upon the opposite party, that means upon us. Regarding this issue, we do not have any objection. But Lordship, we found one vital thing, that in another CO, white CO number 1727 of 2017, arising out of same trial court proceeding, once upon a time,
17, I do not have determination.
Lordship, or in that CO, Lordship was appeared as an advocate in the same trial court proceeding, as an advocate on behalf of the petitioner.
That was not mentioned. What can be done?
Lordship, and Lordship, when it has come in my knowledge, being a court officer, being an advocate, it is my duty to mention before your Lordship.
Yes.
Number 920, my lord. Because they are this whole area.
Please mention that, hand over the slip.
Lordship, due to that reason, I am mentioning the matter for the purpose of inclusion under the heading of to be mentioned.
Why to be mentioned? You file an application.
If you want application,
You file an application. To be
Lordship,
mentioned cannot be, if order has been passed, it cannot be recalled or to be mentioned.
Lordship, then I will file a separate application, Lordship. Can
Contested application নিয়েছে না?
না নেই দিচ্ছি আমি কন্টেস্টেডই দিচ্ছি কন্টেস্টেড নেই কিন্তু আমার
Please indicate that in the slip, hand over the slip.
your lordship
Mr. Pine, please mention that what has been, if it has been directed, it cannot be held. It will appear on that date.
your lordship may I need to your lordship
If at the time of filing, what date you have mentioned, it will appear on that date.
may I have a leave
Can't be held.
your lordship may I have leave to make a contested application to be appear as contested application your lordship but never
List of March.
Contested application, not now.
your lordship there is an urgency your lordship the matter is going up in the April your lordship is for the lower
If you
court.
want, I can put it in the to be mentioned, can release that.
Your lordship kindly opportunity be given your lordship is section 24 matter your lordship
Madam, please consider the motions are there. If you want contested to be taken up, I have no difficulty. I will hear the contested applications first. No difficulty, it's your choice. Whether the motions to be taken up first or the contested.
but
It's your choice. You decide. I will,
your lordship there was a
I will
direction
leave-
but the other side never appeared your lordship the problem is that your lordship
that is neither here nor there. Yes. What do you want?
For argument and delivery of judgment.
Sir, I've said, indicate that in the mention slip, hand over the slip.
Last date is 19, last.
What time you are mentioning? What is the endorsement in the last mentioning slip? Have you checked up? Have you checked up? All the mentioning slips endorsements have been made. Please check up. You say third time, all mentioning slips endorsements have been made. So you will not check up that and you will say, I have mentioned third time. You will be rejected on that. Please check up.
Contested application, there is
Your
a
Lordship, I apologize to trouble you, and this is the first time we are mentioning at least.
What do you want?
Your Lordship, this was supposed to be listed already. This water was heard, and it was supposed to be listed as a returnable motion in the monthly list of March. This doesn't find a place in the list. Mainly,
So that is for inclusion, sir. I've told hand over the slip for inclusion.
my lord, inclusion in the list.
urgency in taking this matter up because
My lord, inclusion in the list.
the DRAT and the DRAT has misconceived the law. It says I have misconceived the law.
That is on merits, sir.
But otherwise,
That is on merits.
it will be heard out. It is on admissibility and pre-deposit. It will be heard out in DRAT. The DRAT
So please mention the urgency, hand over the slip.
So this happened for a long time. Please let it out.
It is appearing in the list.
My lord,
Have you mentioned the ground of urgency? Hand over the slip.
Earlier trial dismissal of this matter has been pending for the learned Patna district for 10 years. This matter filing 22nd December 2024. The 4 years matter has been pending as the public section number 475. Earlier trial.
My lord, there is a direction to appear the matter in the list of March, but it is not
Hand over the
to
slip.
appear.
My lord, only one thing, my lord, on the first day, my lord indicated, my lord will take someday, my lord, the expeditious disposals. Someday, my lord, indicate when expeditious disposals.
Expeditious disposal, Mr. Chatterjee, there is no urgency.
No, my lord, I'm not on urgency. My lord indicated someday, my lord will indicate when all the expeditious disposals shall be taken up. My lord, I'm mentioning,
Every day I am taking expeditious disposal matters.
my lord,
Out of the fresh motions, you will find 8 to 9 are expeditious here.
this is
Every day I am taking.
804 is also same prayer of expeditious disposal, but my lord, it will be heavily contested. I must indicate. My lord, they will oppose the expeditious disposal because my application for judgment upon admission is pending in the court below, which is not been taken up for the account of a receiver, my lord, who is made a party itself in a suit.
Hand over the slip. Yes.
My lord, এইটা include করে।
To make up a custody matter with the direction period for visitation at Joy Digital Library. Below this Sunday, the order was flouted. Below to great extent. Below I have taken out below the application because the next petition or below this coming Sunday. Kindly allow us to go this unlisted.
Not unlisted. Mr. Banerjee, you file
We can get tomorrow.
tomorrow 2 p.m.
Tomorrow. That thing.
File that.
My lord,
File the application.
Supply the number, supply the number. And I told that tomorrow we will possibly the second half application.
Then Monday, Mr. Banerjee. That is why you agreed to 2 p.m. and some whispering from your learned junior, you said no. You agreed to 2 p.m. File,
my lord,
yes.
Partition suit, I am defendant petitioner.
Will it unless this is those that tomorrow is made the returnable date, that I cannot file it, but indicating in the presentation.
Mr. Banerjee, contempt is between the contemner and the court.
Contempt application.
So,
We're just asking for a special officer so that this Sunday someone will remains there.
file, let it appear on Monday. I will consider that. Yes.
Partition suit,
Because
defendant.
without hearing the other side, no order can be. Yes. File it, it will be taken.
Partition suit, defendant petitioner hearing. Preliminary degree pass, partition suit, defendant petitioner.
What do you want?
Expeditious hearing and survey pass.
Running in the list.
No, no. And another important factor, the survey pass commissioner did not file.
It is appearing in the list.
No,
New matter.
2024.
When did you file? It had
That
not
was
appeared in the list.
Once it was appearing monthly, that was not hard at that time. But
Hand over the slip.
My lord, may I just hand over, there is a new motion. My lord, next date in the court below 1st of April, I have indicated the just the date only, my lord, with a order copy of the trial court. My lord, it rejects my petition, my lord.
What was, what application was rejected?
My lord, I prayed for time, that was rejected, but my lord, next date has been
Wait
fixed.
for time and now you are saying
No, my
that
lord, no, my lord, next date has been fixed. My lord, why the suit will not be dismissed for default?
has to be. Because you did not appear.
My lord, my prayer for time was rejected. Learned advocate did not appear, his junior prayed for time. So, my lord, if I am not barred from appearing in the suit, my lord, on that count, my lord, my right goes. But kindly appreciates that. my lord.
You will not appear before the trial
The
court.
lawyer was
and
in
now
difficulty,
you
my lord.
come
He was
before-
discharged on hospital on that day with that medical certificate. It was.
Hand over the slip.
My
Right.
made this matter returnable this week.
Right.
Made this matter returnable this week. but-
Mr. Chatterjee is engaged in this matter.
Oh, no, my lord. I tell your lordship what happened, my lord.
Yes.
In
No,
this-
one you have
No,
given,
no, no. My lord, this
one
is a
slip per advocate.
this is a clarification. My lord makes this matter returnable next week, but my lord does not mention the date for which the matter did not come up the earlier week. So, my lord, for that reason, my lord, it's not coming up. For that omission of the date, returnable date.
It was adjourned.
It was adjourned on the count of the other side. Kindly recalls they were always alleging we have not served the copy of the revisional application.
We will
My
not
lord,
solve what can be done.
My
Mr.
lord
Chatterjee.
recorded in court that now they are being served in full. And my lord, on their prayer, my lord, it was made returnable next week. But the date was not there, for which it is not coming up in the list.
Yes, wait for some time. Yes.
I have permitted to mention one matter, my lord, new motion matter.
What do you want?
Expedite this matter, my
No urgency, yes.
lord. It's pending now.
Maybe. No urgency, yes. What do you want?
My lord,
Mention that in the slip. Yes. Madam, expeditious hearing, there is no urgency.
My lord, may I lordship leave to mention a matter, my lord? Item number 390 of the lordship monthly list, my lord. My lord, urgency is, my lord, there was already,
Please indicate the urgency in the slip, hand over the slip.
my lord.
Yes, Mr. Chatterjee.
Lord, may I have my lord's kind leave to mention item number 505. Lord, Mr. Ritik Chaudhary is before your lordship with the slip. My lord, I would not have, I have heard
If
what
here,
your,
Mr. Chatterjee, if it has, urgency has been indicated in the list, I will go through the.
my lord, Ritik Chaudhary is there. He's there in the, my lord, I can see
Nobody
him.
is here.
But I'll make sure, my lord, it's there. The
Mr.
problem,
Chatterjee, ask him to hand over the slip mentioning the ground of
I'll tell
urgency.
your lordship what my problem is, my lord, because if I was there, my lord, I have heard whatever your lordship has said all this time. I will not trouble your lordship. The problem is, my lord, here, my lord, an arbitrator is involved. I have filed a Section 8 application that has been rejected, and the arbitrator doesn't want to give any time. Even on a Saturday and Sunday, my lord, is proceeding. Kindly appreciate, and the seat, my lord, is in Gurugram. So now I am in absolute, my lord, doldrum.
Attend there, Mr. Chatterjee.
Milord, I cannot attend there, Milord. I am almost a Chashi, Milord, in Mednipur, and he's asking me to go to Gurugram, Milord, because the other side, Milord, is a massive, Milord,
That is the
multinational
seat as per
company.
the agreement.
It's
that
not
by
there,
the-
Milord. I'll show your lordship. It's not there. The dispute
So
is
ask your-
not arbitrable.
Ask your learned advocate on record to mention that in the slip, to hand over the slip. Yes.
No, I'm surprised I saw him there, Milord. Just give me a second. I'll just send him right
Then
away.
he might have handed up the slip.
No,
Ask
he didn't, because I asked him not to. Milord, I'll just give me 1 minute. I'll come back. I'll come
Yes.
back. 1 minute.
To mention a contested application.
No. Yes.
May I permitted to hand over the slip, my lord, for upgradation?
Yes, call the list.
May I be permitted to mention, my lord, I am suffering an order of injunction since 2000.
What do you want?
I am suffering an order of injunction since 2019. In 2022, since there was inordinate delay in the matter of
Inclusion, inclusion what?
upgradation.
Indicate that in the slip.
Mala.
You mentioned it earlier.
No, my lord.
This matter you mentioned earlier.
No, my
You
lord.
did not mention. Hand over the slip.
Milord, the learned clerk is there. I'm Mr. Maithi's clerk. I can see him. Kindly hand over the slip.
My lord, may I just mention one matter?
Strategy, some advocate has to hand over the
I
slip.
keep.
My lord,
This is not done in a high court.
No, he has not handed over, Milord. But probably the lawyer has.
That
No, the
can-
lawyer has. Milord, he's messaged me. He has messaged me. The lawyer has. The lawyer has.
Yes.
my lord, may I just mention one matter? This is an application for extension of interim order. It's expired in the month of November, my lord. Application has already been filed.
Hand over the slip. I told you to mention for under the heading application. Yes, call the list. Call the list.
Your Lordship, for item number 1, I am for the petitioner. The matter has been settled between the parties outside the court. Therefore, I'm praying for
Don't want to
withdrawal.
proceed.
Yes, my lord.
Give the letter.
Settlement letter.
The learned, you are the advocate on record.
No, your Lordship.
Where is the advocate on record?
I'm for the firm. I'm associated with the firm, Your Lordship.
Learned advocate on record has to be there in a non-prosecution matter. The learned advocate, onar naamta likhe deben. Mr. Tenancy, learned advocate appears and submits that he has received
The petitioner plaintiff filed a money suit before the Civil Judge Senior Division, Jhargram. My lord, it was filed in the year 2000. Now, evidence was started, and I'll take your lordship to page.
what has been done. What is the impugned order, Mr. Kundu?
My lord, impugned order 228 dated 4th of April 2023.
What has been done?
My lord, the evidence has been closed. On the ground, my lord, kindly take the last page. Considering the age of the suit and the conduct of the learned advocate.
No, Mr. Kundu, what could be done? DW1 was present from 10:30.
Lordship.
The learned advocate sought for a short passover at 10:35. So till 5 minutes past 2, neither the junior, then the junior also vanished. Senior did not appear.
Lordship.
Then rightly closed.
My lord.
And kindly come to the last part of the impugned order. Evidence of the defendant stands closed as the learned advocate for the defendant has submitted that the defendant would not adduce any further evidence. So this is the submission.
My lord, unless it is reopened.
That is your submission that you need not adduce any further evidence. Mr. Kundu, if you want to controvert this, you have to file a review application before the learned trial judge. That is your submission recorded. Evidence of the defendant stands closed as the learned advocate for the defendant has submitted.
Well, I am the plaintiff. I'm not defendant.
Then how are you prejudiced? You are the plaintiff. How are you prejudiced?
My further evidence has been closed because of the learned advocate.
No. Your further evidence has not been closed. It was for the defendants.
Yes.
Your further evidence has been closed prior to that. That order is not under challenge. So now it's the defendant. After Mr. Kundu, after the closure of the plaintiff's evidence, date is fixed for the evidence of the defendants. So this was the date fixed for the evidence of the defendants, not of the plaintiff. So how are you affected? You are the, I thought you were the defendant.
Well, the next date is
Plaintiff.
well, next date is fixed for argument.
Yes. Advance your argument. There is no difficulty. You are not prejudiced. You have laid your evidence. This application under Article 227 of the Constitution of India is a Yes,
My lord, this is, I suffered the ex parte decree. I came
you
to
are opposing. To appear, my lord, since there is no candidate, but I have my vocal now. All right, let me see. You are ready with the facts? Not yet. Yes, yes.
my lord, ex parte decree obtained, as on day, the bailiff set and postal set are all lying records.
After 9/13.
Yes.
What happened after that?
Thereafter, I entered appearance in the execution here also and paid for stay of the execution. And in the order dated 11th February 2025, where without any hearing, the learned advocate rejected my application. On the only sole finding, it appears that no sufficient order or status report or miss case number so and so has been filed to stay the execution. Without any hearing, without reason that nothing.
No,
And
no,
can
what
you-
is, what happened on 5th of March? What is the miss case of 1 of 2025?
My lord,
What is the miss case 1 of 2025?
yes. Oh, see, that is fixed on 9th of paper evidence.
What is miss case number 1 of 2025?
This case is for police help. Paid for police help. My lord, not 208, that is a order rule 97. That after clumsy, making clumsy, make it conform, order rule 97. For a moment.
Have you received a copy of the order 9/13 application?
Right now.
All right, you serve him a copy. When this is next,
My application, my lord. But the case is that
5 or 4?
4.
Yes, Mr. Strategy.
Yeah, my lord. Kindly see the order impugned first, my lord. Then I will portray the entire case in a brief form, my lord.
What is the order impugned?
The last order.
Yes. What happened?
My lord, initially, my lord, there was a suit. The suit was preferred by the opposite party number 2 against the present applicant as well as the petitioner, my lord. And that suit was dismissed on 8/4/2010. It was filed in the year of 2000.
So what is this misappeal arising from?
It is arise from the demolition order passed by the municipal authority, my
So
lord.
this is an appeal under section 200 subsection
200
218 subsection 3 of the West Bengal Municipal Act.
Yes, my lord. This is the case, my lord. My lord, what happened
You have
actually?
raised an unauthorized construction, Mr. Chatterjee.
Unauthorized construction.
It has to be
My lord,
demolished.
my lord, kindly appreciate, kindly consider my case.
Unauthorized
No,
construction.
my lord, there is no,
You admitted that you have raised. I asked you. You said yes. You have made unauthorized.
but there is
construction.
no unauthorized construction at all, my lord.
I asked you whether you have made. You said yes.
Sorry, my lord. It's my fault, my lord. Actually, I mean,
Yes. Who appears for the municipality? Where is your miscellaneous appeal?
Yes, my lord.
Stay application, where is the stay application? Stay application was rejected.
The application was rejected.
Where is the stay application? Have you annexed?
Yes, my lord, I have annexed the stay application.
There was an order passed in a writ petition also.
Yes, my lord. Order passed in a writ petition, appeal preferred. In the writ petition, my lord, I was unrepresented. That's why I preferred an appeal, because the matter was listed without
What
serving.
did the division bench say?
My lord,
To
kindly,
consider and to pass an order.
division bench, my lord, kindly see the division bench order, my lord, page
Yes.
136, 37.
136.
Yes, my lord. 136, 134 onwards, my lord, the order was start. And
Yes. Do you have a sanction plan?
I have a sanction plan, but it was withdrawn in the year of during, my lord, may I submit the case, my lord?
Yes,
Kindly,
sir, strategy.
my lord, kindly,
Without any sanction
kindly
plan.
spare me for a moment, my lord. I portraying my case, my lord. What happened, my lord? Initially, the opposite party number 2 has preferred a suit against me, suit for declaration and permanent injunction, as well as the unauthorized constructions.
By the order impugned. The yes.
I am the tenant. Petitioner is a tenant in a suit for eviction. Lord, what happened, my lord? There was at the time of inception, there was an agreement for tenancy agreement. Lord, as per this agreement, tenancy rent will be enhanced at the rate of 10% per of the existing rent after every 3 years. Now, there the suit was filed. Was, section under 7(2) application was filed. But in that case, in that application, there was no specific direction for payment of enhanced rent. But it was the particular clause of the tenancy agreement was recorded, noted. It was admitted position. And thereafter, my lord, suit up to 2016. Thereafter, I am paying the rent after every 3 years at the enhancement. Voluntarily, my lord, there was no specific direction. Last time it was enhanced, the 3-year cycle was expired on April 2023. Thereafter, my lord, by bona fide mistake, I missed the enhancement. I continued to pay.
Where is the order under section 7.2? Where is the order under section
Order on
7.2?
the 7.2, page 47. 45.
Page 45.
Page 45.
What was the rate of rent adjudicated?
Rate of rent adjudicated, my lord. Kindly come to my lord, page 45. Area amount was adjudicated at rupees 37,268 at page 47. 47, later part, my lord. And thereafter, my lord, there was
Rate of rent was not adjudicated.
rate of rate, my lord.
At that point of time, there was no dispute.
Rate of rate was not disputed, but agreement was noted. It was noted that agreement was there. Initial rent was 2,000. Thereafter, it is liable to be increased. As
No,
the-
this amount of 33,880 was for 14 months.
14 months.
So what is the monthly rent? How much it comes?
420 at that point of time.
2420.
At that point of time. Therefore, it was enhanced to after 3 years 2929.
2662.
2662.
Yes. Thereafter, 292.
But I am not. I miss the area rent. I am continuing to pay the current rent, last paid rent. On discovery of the mistake, not bona fide mistake, I started paying rent at the enhancement from July onward, July 2024 onward. For 15 months backlog, I applied for that payment of leave to file the backlog by filing application under section 151. Now that was rejected. But the only ground that
At this stage,
at this stage it is not a mature stage. DW1 evidence of DW1 is going on. At this stage it cannot. There is no single month's default since not this order of under section 7. Single month's default.
This is default.
Only enhanced rent.
That is also a default.
By bona fide mistake.
we are continuing to pay.
Yes. What
Last
is
paid-
Demand and payment like
Hear me.
7.
that he is admitting? That he is admitting. But after the suit is filed under section 7.2, whether this enhancement is to be considered or the rate of rent last paid. Consistency একটা দিন তো।
Statutory notice they have to waiver, that amounts to waiver of statutory notice. If they
What does section 7.2
agreement,
say?
that is the point to be considered. After termination of tenancy, there was no direction, specific direction by the
Having regard to the rate at which the rent was last paid. So last payment is the criteria, not enhancement,
That is the
not enhancement.
I'm voluntarily giving. That's all.
You are not entitled to enhancement.
Agreement not disputed. Lord.
Maybe statute says last rent paid because you have filed a suit.
There was no specific direction of.
You have filed a suit. So agreement, so that is, what is the suit? Agreement terminates on that. Because you want eviction.
The type of passing solar losses, page 46 lot. That takes in the order sheet 10% including considered losses by this order.
That issue was not raised. He has not challenged that. Then you would have not got that amount also.
Admitting order sheet.
Says rate of rent last paid.
That's it.
So you are not entitled to any amount. So nothing remains 151. You go on paying at that rate. You will not be prejudiced.
Can you observe this?
By the order impugned. You file a 227 if there is a delay. Yes, next.
My application, my lord. My lord, it's an innocuous spread. I'm only seeking expeditious disposal of my order 13A application under the Commercial Codes Act. Instructed over. There is no caveat.
Expeditious hearing of our application.
Yes. Under order 13. Yes, yes. No, I'll indicate why. No, without gun.
Chance given to me to file the.
Malal, I'll just.
It is fixed for hearing already.
Written objection.
It's not fixed for hearing. That is my only. If my learned.
Show me
Yes.
the order.
Malal,
Showing, do you have a copy of this application?
already served. We served out of abundance.
Received over WhatsApp yesterday at 10:30.
Though there is no caveat, I've
There is
served
no-
out of abundance. It's an innocuous spread. Page 200, Malal, will kindly come to page 200.
200.
200.
No, what is the impugned order? Show me
Malal,
that.
impugned order is 4th February 2025. That's the last order.
4th
I want to.
February 2025.
Yes, Malal.
No, there is another order of 13th February 2025. That is the subsequent order. Why are you saying 4th February is the last order?
No, Malal.
10th February is also there is another order.
Malal, 4th February is the order impugned. I'll indicate why, Malal. 4th February, because after that, that's a separate application. 4th February is in respect of the application I'm seeking expeditious review. Malal, will kindly see what has been done. The application was filed, Malal, on 17 January 2025 with copy served. 30 days is a statutory period as per the Commercial Codes Act for them to file a reply. It's a statutorily mandated period of 30 days. Anyway, I will indicate from the act itself, it's 30 days. Thereafter, my lord, fourth,
Directed
There-
petition not mandatory.
I am saying, my lord, I am only seeking a direction that 4th February 2025, the operative portion at page 202, my lord, 16th April has been fixed for them to file their opposition only. My lord, let that be also for hearing. Let them file their opposition in the meantime. Let it also be for hearing, because that is what the act, or rather the statute mandates, my lord. My lord, may I hand up a copy of the Commercial Codes Act? May I hand up a copy of the act, my lord?
Yes, Mr. Gupta, you file your objection prior to that.
Yes, that's all.
So I'm directing this application to be taken up for hearing.
Yes, that's all. 16th
16th of April.
Yes.
I have simply submitted on the lines of the opposite party.
This is only a direction to
Take it up for
that
hearing.
application to be taken up for a hearing. You don't want that.
Only one.
I'm only passing that direction. You file your objection, if any, in the meantime.
They have not yet received the Vakalatma because client is
Let
not
them
yet
file.
picked up. So that is why not, I was humbly beseeching that if it could be taken up on Monday, we should file the Vakalatma and the same.
You procure your. I will record your submission that you have instructions to appear.
Yes. Oblige.
You file your written objection. How soon can you file your written objection? So do that by the end of March. File that with the by the end of March, 16th of April. I am directing the learned trial judge to.
My lord, will kindly see Rule 4. Order 13, I have opened the book, my lord.
Yes.
Rule 4. Firstly, Rule 2, my lord, will kindly see. Rule 2 says I cannot file this application before service of summons in the main suit. Summons has been served. I filed the application thereafter.
The written statement
Yes,
is
yes.
already on.
And thereafter, Rule 4. Yes.
You are the
I am the plaintiff, my lord.
that you have not indicated in the cost title. This application
I'm for the petition. And this is for the transfer of proceeding from Bakura to Chinsuda.
From
Bakura to Chinsuda. The present plaintiff petitioner is 62 years and not in a position to work. My lord, I have annexed the medical papers, page 100.
is that the evidence stage? Your evidence is going on.
My lord, kindly see the medical
All
paper.
right, what is the next date? I will direct only on that date cross-examination to be concluded.
38th April is the next.
Yes, on that date, I will direct chief. How much time you will take to conclude your chief?
But it is partly concluded from the order sheet. On 12/8/2024, he was examined as PW1, deferred the 12/8/2024. He was partly examined. Thereafter, he was not in a position to travel such a distance. And page 100 is the medical papers.
12/8/2024.
Yes. The supposed
Yes. 12/8/2024. And the next date, one day you go there, cross-examination, I will direct. If you can conclude your examination in chief, on that date, I will direct the cross-examination to be concluded on the very next day.
On 38th April 2024.
30th April. How much time you will take to complete your examination in chief? How many documents you will?
I don't think much time will be required.
Much time. 15 minutes.
But only difficulty is that he is not in a position to travel such a distance.
Evidence stage, it will delay. You are interested, money suit. So you are interested in expeditious disposal of the suit. So it will delay transfer. So I am directing this.
Kindly see the medical papers. Kindly see the medical papers what doctor suggests. Not to travel, not to.
Where are those medical papers?
Page 100.
Page 100.
A series of medical papers is there. It's from cardiac disorder.
So then it seems that you do not want expeditious disposal of this. All right, I will direct you to serve. No stay.
I want, but not in a position to travel such a.
All right. So they have to be given a chance
Yes.
at this stage whether it can be.
Monthly list of June.
Yes. Yes, Mr. Rai.
This is an application filed under Order Quarter Rule 27. That was. That was rejected.
Prior to the hearing of the appeal.
And deem can you turn to the order impugned dated 21st February 2025?
21st of February, yes.
The three orders are there, my lord will find.
Yes, yes.
Today's issue reply to law points by appellant in default closed and hearing a petition on 4127.
This is the difficulty, Mr. Rai, when you are being engaged to appear in a
Can
learned advocate from the Calcutta High Court will travel. That is the ground.
Senior advocate, my lord, can you consider senior advocate?
Court considers you as a senior advocate.
Lord. Constitution is
The difficulty.
senior advocate. It is not me. Now, my lord, can you turn to the next order? First order, my lord has gone through. Hence, the reply on law
Mr.
points.
Rai, what do you expect the learned trial judge, the
On
learned
the
first appellate court to?
The learned
So
advocate-
we will keep waiting for the learned senior counsel for the entire day.
Not,
So this first, it was deferred till
it is fixed at 2. Fixed at 2.
2:30 you did not appear. Then at
2:45.
3:30
No,
you have
these are
filed an
the-
adjournment
So,
petition.
my lord, can you consider?
So senior counsel, Mr. Rai, will not have any advocate on record or junior advocate.
47, my lord.
Will also not take any steps.
47, my lord, can you turn to the 47, my adjournment application?
40,
47.
page 47.
Yes.
You will come for expeditious hearing and you will not appear and say yes. Yes, adjournment petition.
At 2:35.
Yes.
Prior to an application was filed. My lord, can you consider the order next for an order passed at 2:30. Hence, the reply on law points on side of the applicant deemed to be heard. Argument is therefore closed. It appears on the record such as applicant stands rejected.
Yes. You have not moved that application.
If that be so, my lord, whether rejection is amounts to default or not. Rejection of an application and without moving the application which is dismissed for default. Whether the rejected can be termed to be the same.
I am clarifying that.
The clarification other side is there. But
They will not be prejudiced. From
They will-
rejection to dismiss for default, they will not be prejudiced of that. Mr. Rai, you need not be concerned about the opposite party.
I
Take care
want
of that.
only one thing, my lord. I want to participate in the proceedings. Only for you.
21st of March.
And it is fixed on delivery of judgment. Everything closed, delivery of judgment. Law point was ready.
Sir, come back tomorrow at 2 p.m.
Tomorrow by 2 p.m.
Yes.
2 p.m. We will be busy, my lord. Tomorrow 2 p.m.
Yes.
We are busy.
Why?
For some other reason, my lord knows. It is our also.
Monthly list of April.
এটা কি? Tomorrow. এরকম করলে হয় নাকি?
Right.
And this is the
That can
only
be done.
thing. If your lordship can fix
These type of orders are interfered with. No proceedings will end.
my lord, please consider, if I could have understood that previously this was dying on a checkered history, I could have not mentioned if your lordship had moved this matter. Here is the only solitary day, my lord. When,
And this was fixed for, I think, of argument.
yes, in default argument, or about rule 27 and law point, reply on law point.
Law
That was
point,
it.
that is argument, title appeal.
That
What is the suit for? What is the law point?
The law point is how a person should be declared to be Sunni or Shia.
How the person will be?
Declared as a Mohammedan community, how it be declared as Sunni or Shia. The way of evidence will be debate upon their. And I find some document from where it will appear the predecessor of the defendant plaintiffs.
By the order দুটো
May it please your lordship, my lord, I'm for the petitioner. My lord, this is an excruciating saga of the senior citizen lady petitioner, my lord.
expeditious hearing of what?
My lord, for hearing of the main suit as well as the pending
What is the
applications.
stage of the suit?
My lord, except for the.
For hearing of the non-maintainability petition.
My lord, still for 10 years it's happening, my lord.
12th of June, it has been fixed.
My lord.
So I'm directing that application. If it is,
However,
if it is decided suit is not maintainable, everything goes.
my
This
lord,
application-
however, a development has happened after filing of this particular civil division application, my lord. I find that there an order has been passed by Honorable Justice Dr. Ajay Kumar Mukherjee. Now, he has his lordship has also mentioned that it has to be completed within 6 months, my lord. Would your lordship kindly peruse that order? It
If
has
that
been,
order is there, there is no necessity to
My
only
lord.
in this suit.
my lord, the defendant number one, the opposite party number one, has initiated that revision
Oh, and
application.
this
my
is
lord.
your application.
My lord, it has happened after we filed it, my lord.
So the defendant is faster than you.
24th of February, my lord, he obtained that order.
Ashun, this application under
I'm appealing for the petitioner. Wife defendant in a matrimonial suit is the petitioner before your lordship, my lord. By this application, wife petitioner has prayed for transfer from the court of learned additional district judge at Barasat to the court of learned district judge at Baharampur, my lord. Only the summon has been received. Next date is 4th April for service return, my lord.
you appear file your statement there.
No, no. First
Why?
time. This is very difficult, my lord, because I am residing with my parents at the Baharampur. I have 4 years of child, my lord. It is very much difficult to travel 282 kilometer ways my distance, my lord, from Baharampur to Barasat, my lord. It is nearly to 11:30. I will, I suppose to appear, my lord. In the meantime,
You are a working lady.
no, I am housewife.
Housewife.
Housewife, my lord. Totally dependent upon my parents, my lord. Nowhere. No one in my parental house to assist me to appear before the court of learned district judge at Barasat, my lord. Moreover, 4 years child is residing with me, my lord.
This
Suit for
Yes, Mr. Doctor.
declaration, suit for declaration only with regard to validity of possession. Whether the suit of the plaintiff, whether the plaintiff has a valid possession or not. Injunction refused by the first court, appellate court granted injunction.
The defendant.
I am the defendant. Only the possession has been sought to be declared, and no title, nothing. He admits that he doesn't have title. On the basis of one Amul Nama, which I say I had never executed, neither my predecessor had executed, the appellate court granted that let status quo be maintained.
Mr. Doctor, this is against an ad interim injunction or temporary?
Ad interim injunction.
So,
Ex parte.
yes. So
First
this
court
ex
refused.
parte, it cannot be stayed, Mr. Doctor.
First court
Ex parte, it
refused.
cannot be stayed.
The first fact-finding court refused.
Maybe.
Prima
But
facie did not find.
maybe because this order, there are series of decisions, it cannot be stayed. There are two ways. I can direct the injunction application to be disposed of. Because it's at the ad interim, you file your written objection. File your written objection, I can, what is the date fixed? Because you are the defendant.
Yes.
If you appear, it will be made ready. If you file your written objection.
Within a short time. The writ petitioner before your lordship is a nonageri, 90 years.
No, I could not follow.
The petitioner before your lordship is almost about 90 years and a patient
More
of
so,
cancer.
because otherwise this will be kept pending here. Because this only against ad interim.
Yes.
Temporary has to be decided.
Yes.
So, and there is no scope to pass an interim order to stay this.
But,
What is the next date fixed?
next date fixed.
Have you filed your written
Yes,
objection?
yes, written statement filed. Written statement, no, this has been disposed of. This
Written
has
objection to the injunction application, not in miscellaneous appeal
no.
before the trial court.
In the trial court, written statement filed, written objection not filed.
No.
Written objection also filed. Oh, written objection also.
Also filed. What is the date fixed
Next date copy fixed.
in the trial court?
Last date was on 5th of March.
What is the next date?
Next date.
Or I can direct on the next date fixed to take up the hearing of the injunction application and to dispose of. Ashun.
The fixes a period of 60 days at least.
I've also filed.
In anticipation, Mr. Dotto, another appeal we will file and that order will be passed. Yes.
For the part.
There is an.
You are for the petitioner.
I'm for the petitioner. Plenty before the learned trial court. My order one, this is the dispute between husband and wife. Husband has a property, suit properties belongs to the husband, admittedly. I only prayed.
You are the wife.
I'm the wife. My
4 years.
Please allow him to make a submission, he will be getting a chance.
My suit is regarding that I can use my husband's property uninterruptedly along with my husband. This was my declaration before the learned trial court.
Any matrimonial suit pending?
No.
Nothing.
No. And meanwhile, the suit, the injunction has been granted, and thereafter injunction has been absolutely granted till the disposal of the suit. And my one application under order 1 rule 10 was pending before the learned trial court. That was also rejected by the same order.
Why application under order 1? What is this proceeding for?
The suit
for? Who filed? You have filed the suit.
Yes. And my prayer is from the page number 18 onwards.
Stay and enjoy without any interference of anybody. Shared household.
Yes.
So this is your suit.
This is my
such a suit. Whom do you want to add?
Meanwhile, when the written statement was filed, I came to know the part of the property has been transferred to my daughter.
Your daughter?
Yes. Our daughter. It has a transfer. So I want that her right has been created. If the suit is decided and later it is found that the daughter has a right, without hearing the daughter, if the matter is being heard of, then the right of the daughter will be jeopardized. I pray that my daughter should be added as a party defendant in this suit.
So first part is the injunction.
Injunction was allowed.
That you are not.
I am not agreed by that order. My order on rule 10 application from page number 35.
But your claim is restricted. You have not made your claim against the daughter.
No, I have not made claim against it unless until the daughter. I came to know regarding the transfer.
You have a right to use your husband's property.
You
have a right to use your daughter's property as well.
The entire injunction has been granted over the property.
Maybe, but do you have a right over your daughter's property?
No, I was not, when the suit was filed, I'm
asking you. If you want to add the daughter as a party, then you will be also wanting injunction against your daughter.
Because
against your daughter. So show me that you have a right to use your daughter's property. No. What right you have?
No, my lord,
to satisfy that. Otherwise, how she is a necessary party? Maybe it has been transferred.
It has been transferred, but the suit is over the entire property. I was not aware regarding the transfer of that property. I was not aware. But when the injunction was granted absolutely over the entire property. From the written statement I came to know.
What is the main dispute?
Main dispute is that I'm telling you, I'm very frank. Main dispute is regarding the son-in-law.
Daughter has been married.
Yes. Daughter married near about 20 years back. Son-in-law is controlling the father-in-law. How I cannot say, but it should not be. There's a 80.
Mother has been controlled by
the entire property has been gifted to the daughter.
A part has been gifted. The part is at first floor. Part is at first floor.
And you are staying in?
I'm staying in second floor. The daughter will disturb me.
The gift has been in the first floor, but you are in the second floor.
I am in the second floor.
Yes. So you have you have not claimed your right with regard to the first floor.
Yes. This is entire suit property.
Show me where have you stated that you have.
See from his pleadings in paragraph 14.
My lord, kindly see the.
Paragraph 14.
Let me finish, sir.
All right. I'm coming after 5 minutes. Yes.
Well, kindly look into page number 20 of my application.
Give me a minute.
This is the schedule,
Give me a minute.
schedule B. Schedule B, there is a 3 flag.
Give me a minute.
Oh, my lord. I'm sorry, my lord.
Where is your application?
Application, my application under order 1 rule 10, my lord. It is from page number 35 onwards.
35.
35.
Yes, where is the deed of gift?
Deed of gift is not with me.
Yes.
But it is stated in the page number 20, the written statement. By the
Page
written,
number?
In the written statement starts for page number 23, especially in the page number 27, when my husband, there's a defendant, has disclosed it, I file a order on rule 10. Page number 27, paragraph number 17, my lord.
Yes.
I want to add my daughter as a party defendant in this suit.
But your allegation is not against the daughter. Your allegation is against the husband.
My allegation against the husband, but the suit property now, and at that time I was not aware that the suit property, part of the suit property has been transferred to my daughter. So unless the daughter is the party defendant, then
file a fresh suit against the daughter.
And in this suit,
It will change. It will enlarge the scope of this suit. Because here, in this suit, the scope is a dispute between the husband and wife. So now the scope will be enlarged. So it will become a dispute between the mother and the daughter.
mother, because of
file a separate suit. Nobody is stopping you. This here cannot be added. Nothing prevents you to file a separate suit against the daughter. You file a separate suit challenging the deed of gift, whatever you want, you can do that. But not in this suit.
Paragraph 15 of our revisional application.
Yes.
Paragraph 14. The petitioner states and submits. It was done in her presence.
No, that I came to.
In her knowledge. She cannot deny.
That doesn't mean that I came to know in the year 2022. That is my awareness.
This is her submission in affidavit. 13 to 26 are my humble submissions. And take paragraph 7 of the plaint, which is at page 13 of your lordship brief. The plaintiff states that in the Schedule B property, the plaintiff and defendant are residing peacefully. So there is no dispute at all between the plaintiff and the defendant.
This
My lord, this is my petition, my lord. My lord, I am filed this present petition impugning an order of 16 January 2025 passed by the learned West Bengal Land Reforms and Tenancy Tribunal, third bench. My lord, the order is at page 63. My lord, my grievance against the order.
Can it be challenged before the learned single bench?
Not, my lord. Possibly.
Possibly, yes or no? Possibly you have stopped at that.
No, my lord.
Then, do you have a copy of the West Bengal Land
Yes,
Reforms and Tenancy Tribunal Act? 226, 227 before the division bench.
But I had flagged the section, relevant section.
Which section you have flagged?
50. West Bengal LRTT Act.
15.
50, my lord.
50. What is 50?
5 section 50 of the LRTT Act, my lord.
50 of the LRTT Act.
I had flagged.
LRTT Act does not contain section 50.
But I had flagged it, my lord. May I?
LRTT Act only has 25 sections.
My lord, may I just see the bare act once more? I have flagged. I'm so sorry, section 11, my lord. That will be the different act.
Section 11.
Yes, ma'am.
By the order impugned.
Okay, Lordship, I'm for the petitioner. Lordship, this application is for a expeditious disposal of a title suit.
Expeditious disposal of what suit?
Title suit, wherein the petitioner has filed its suit.
What is the stage of the suit?
Lordship, the stage of the suit, evidence has been completed, Lordship. Now, the delay is being paused as because if a Lordship kindly comes to the...
What happened on 5th of March 2025?
5th of March. 5th of
That was fixed for evidence of DW.
No report was has come to the learned court. Report regarding the right.
Call the next matter.
Well, no purpose will be served as because second court is not, my lord, allowing us to move, my lord.
Where is the
because-
decision of the Honorable Supreme Court which says that no time-bound direction should be passed? Have you brought that judgment?
My lord, that's my lord, I have got in criminal matter, my lord. That is criminal matter. But here, my lord, only one. If this is the obstruction we are facing, my lord. Here, my lord, order 12 rule 6 have been filed, has been filed, my lord. That was evidence,
Judgment on admission, it will be passed. Yes.
but without, my lord, that diary, my lord, court is not proceedings. That is why, my lord, I have come before your lordship.
Then you have to challenge some order. Then you have to challenge any order. Not a direction for simplicity or for expeditious hearing.
Only, my lord, only
Challenge that order.
court.
If you are aggrieved by some order, then
Order is, my lord, for report, for report, for report. So what order I will challenge, my lord? So, my lord, can you direct the learned trial court to direct the IC?
all right, আসুন। দিয়ে আগে ফাইলটা দিন।
It is an order against the ESI court, 23rd December 2024.
দিয়েছেন তো এটা।
It's an order against the my lord. First, the case is the opposite party was suffered an injury at the time of the employment while working. And then his matter was referred to the medical board. The medical board has come to the conclusion that he has 0% disability.
What percent? 0?
0%. My lord, now the he
Now what do you want?
now he moved before the ESI. ESI court has got a wrong order. Kindly come to the issue number 2.
So here it says degree of permanent disability is 14%.
Now, why he has first this order is wrong. One is kindly come to page number 3, internal page number 3 of the order, issue number 2.
Page number 3 of the order.
No, page number 3 of the order, issue number 2.
Yes.
In the issue number 2, it is written there, last 1, 2, 3, 4, 5, 5th line, exhibit X1 is the medical report, and medical report speaks the probable cause was accident and fracture was there, 5th metatarsal of the left bone. Left leg X-ray report speaks itself, the fracture in the base is the 5th metatarsal bone. The fracture is in the 5th metatarsal bone. Now the ESI court has come to the conclusion that the while passing the order, yes, my lord, now come to the issue number.
What is your claim? Your claim is 30% loss of.
I'm ESI. I'm for the ESI.
Oh, you are for the ESI.
ESI.
Yes.
And now he has posted a wrong order.
Serve upon the opposite party.
But then let the order be stayed.
Why?
Because there is a direction of payment of rupees 3 lakhs to the
Deposit that.
But order is wrong. My lord, I'm coming to
Let them come.
My lord,
Money decree.
my lord,
Conditions can be imposed.
my
Deposit that, stay.
conclusion why the order is bad.
But that cannot be stayed. Money degree, that will be on merits. Deposit that, stay, or serve and then come. Court can grant conditions while granting an order of stay to an order directing payment of some amount. Conditions can be imposed. You are well aware. So, if you want stay of a money order, conditions
Well,
you have to do.
you have to
Ashwin,
pay the
petitioner is directed to
to appear on the unfortunate landlord, defendant caveat.
unfortunate landlord
6 rupees
and tenant is fortunate.
6 rupees.
Tenant is fortunate.
What happened, my lord?
Yes, yes. What is the impugned order?
Order, my lord, this whatever for moment, my lord. Under section 7(1), my lord, depositing the rent. Subsequently, my lord, unfortunately, my lord, due to the sickness, my lord, you cannot deposit the rent in the month of May.
No, I could not follow.
Up to
7-2 was disposed of.
disposed of. 7(1) was disposed of.
7-1, 7-2 disposed of. What happened after that? You have
Accordingly,
complied with the order
Yes,
under
ma'am.
section 7-2.
Seven.
Thereafter,
thereafter,
there was a default.
up to post Bengali month, my lord, up to post deposit the money within time. But due to on March, my lord, in the month of March, they have to delay, my lord. According to approach the landed court, for application 151, my lord, that application was rejected, my lord. Again, that by I continue. But lordship appear not 7-4, my lord, the tenant is entitled to benefit the 7-4, my lord. 7-4 was
Sir, I am bound by my own judgment. I am bound by my own judgment.
Lordship judgment, my lord.
Then I am bound by my own judgment. Exactly on that. After 7-2, compliance, any default cannot be condoned.
My lord, 7-4, my lord, at least, my lord, one, my as per.
What can I do? I am bound by my own judgment. You have got that judgment. Then
I come back on Monday, my lord. In the meantime, lordship, for a moment, well, let me.
Lordship, kindly see the impugned order. Kindly see all judgments have been considered by the
All
last
judgments have been considered.
Kindly see the impugned order. It will speak, res ipsa loquitur. It will speak for itself. Initially 72 and 6 was default amount. It was upon adjudication of 72, it was deposited and then this default. Rent of 6 rupees in the ID Tola.
So for 2 months.
1 month.
1 month, my lord.
Month.
1 month.
My
After
lord,
disposal.
my lord, here, my lord, all more, my lord.
I
7
felt
to my
70.
lord. 7 to disposed of, my lord. Prior to that, entire money was deposited, my lord. Subsequently, passed an order.
6 rupees is the rent.
Yes, Lordship, that's why I am unfortunate.
What is the extent of tenancy?
Lordship,
When you were inducted? One room, where?
Correction,
Where?
ID Tola, Jorabagan police station.
So you can fetch a similar type of accommodation in that same locality lower than rupees 6. Why are you fighting for this 6 rupees? You can get a similar accommodation in that locality at a rent of less than 6. Why are you fighting for this? Vacate that, go to another.
So far as 72 is concerned, my lord, passed an order admitted. But prior to that, my lord, prior to that, all the monies were deposited. Accordingly, the London trial passed an order.
78.
Passed an order that as
that you have complied. There is no dispute with regard to that.
prior to that,
Prior to that, after 7.2, but there is a default with regard to 7.1c. There is a default with regard to compliance of 7.1c.
Lordship. But lordship, 7.4, on the one opportunity should be awarded to the tenant, my lord.
Where is the scope? Show me. Show me the scope in the statute.
Statute by 7.4, more, my lord. 7.4, my lord.
7.4, if you comply, Prat 7.4 comes after 7.3. So you cannot go to 7.4
I am there in 7.3.
without crossing 7.3.
It was in combined order, it was passed.
So-
151 rejected, 7.3
And
allowed.
7.3 has been allowed.
Lordship.
So 7.4 you are not entitled. Awesome.
petitioner come up with a very innocuous prayer, my lord. What happened?
Then no caveat, my lord, may I?
My lord, even no, my lord, I think prayer I will make, my lord. No service.
What is your prayer?
My lord, this suit was filed, my lord, challenging a order of demolition. First, under section 177, one of the my lord, Municipal Corporation Act for declaration, the notice is bad in law, and the injunction to restrain them from giving effect to the. I filed an application for injunction. The identity order of injunction was refused. Surprisingly, no date was fixed for the hearing of the injunction application. Thereafter, on averring some change circumstance, my lord, I filed second application for injunction under 94C. Of the
No, the trial court is requested to dispose of the application within 2 months from the date of
Yes,
communication.
sir, even after this order was made, my lord, the order was communicated. Your lordship will kindly come to the order impugned. That was taken note of, but no date has been fixed for the hearing of the injunction application. Your lordship kindly see the order dated 25th of February 2025. By innocuous prayer.
What is the next date?
The next date is, my lord, 3rd of May.
3rd of May.
Yes, but within 2 months it is not possible, my lord. Let a date be fixed in the spirit of the order of that.
I'm directing that injunction application. You have filed your written objection. If not, file that in the meantime. Where is the order passed in the miscellaneous?
My lord, I am appearing on behalf of the petitioner, my lord, led by Mr. Rohan Banerjee.
Yes.
That by the impugned order, that learned trial court rejected my amendment application after going the merit of the matter, my lord, and admitted in the case, my lord, though issue was framed as per my instruction, my lord, but though the trial has not yet been commenced till date. Because the affidavit in my application, I have mentioned that at the time of preparing the affidavit in chief.
Trial has not commenced.
No, my lord, because
And this was rejected on that ground.
ground and other ground is that they consider the trial court considered the
Order impugned. The application. None appears for the petitioner at the time of call. No accommodation has been sought for either. CO number such and such stands dismissed for default. Next.
A recalling of PW1 was rejected.
Rightly.
So plaintiff is the petitioner of your lordship. Suit for declaration injunction. In such a suit, my lord, the case of the plaintiff is that the person was the
Why do
owner.
you want to recall PW1?
Yes, my lord, kindly consider during the pendency of this suit, my lord, death certificate, page 25.
Give me a minute.
The order for page 25, my lord.
I'm coming. Please give me a minute.
What are the
Yes, page.
Page 25.
Yes.
You all shall find the name of the disease, Hajiman Bibi. My lord, got it. Wife of Lal Muhammad. Right hand, third column.
Wife of?
Lal Muhammad. Name of spouse?
Yes.
Pause there for a moment and date of death is 28/11/1988.
Yes.
And now I can turn to the defense case, page 21.
21.
Yes, my lord. The devolution of interest in favor of the defendant. Emote, from the middle portion, my lord will find Emote Lal Muhammad Sheikh Bittante.
Emote, yes.
লাল মোহাম্মদ শেখ বৃত্তান্তে লাল মোহাম্মদ শেখ ত্যাক্ত নয় সম্পত্তিতে 50% সম্পত্তি তার 5 পুত্র প্রত্যেকে 10% করিয়া প্রাপ্ত হয়। প্রকাশ থাকে যে লাল মোহাম্মদের স্ত্রী লাল মোহাম্মদের জীবন মানে পলগ্রমণ করিয়াছিলেন।
Yes.
Lal Muhammad died prior to 1988. Our case was
where it has been stated. Lal Muhammad died prior to 1988.
Lal Muhammad.
You have purchased from Fajiman.
No.
You are claiming through Fajiman.
Fajiman, if the Fajiman was there.
You are claiming through Fajiman.
One of these.
Yes. Show me that Lal
No,
Muhammad died.
Apart from that, one can turn to my plaint.
No, that is your case that Lal Muhammad died prior to 88.
No.
So Fajiman will not inherit anything.
No. Fajiman died after Lal Muhammad. If I can prove the same, my lord, the case made out by the defendant is that
So you said Lal Mohammad died prior to Fajiman.
Fajiman. Their
Yes.
case is that Fajiman died. So that is why I turn to page 13, my plaint. Page 12.
Page 12, yes.
No.
Page 12.
Yes, my lord, page 12, your lord shall find from the middle portion. বর্ণিত প্রকারে রেজিস্ট্রেশনের বুনিয়াদে গত আলাউদ্দিন তথা বাদিনীর আদনমৃত
I have not got.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 line from the top.
Yes. It's
অদনমৃত স্বামী
Odunamrito, yes.
স্বামী নালিশি তফসিল বর্ণিত সম্পত্তি ভোগদখল করা থাকা অবস্থায় তদীয় স্ত্রী তথা বর্তমান মোকদ্দমার বাদিনীর ভক্তি শ্রদ্ধা সাচ সন্তুষ্ট হইয়া স্বেচ্ছা সরত করে তাদের কর্মরত অবস্থায় যৌক্তিক মৌখিক হেবা বলে প্রদত্ত সম্পত্তি সম্পর্কে জঙ্গিপুর এডিএস এর আদালতে লালিত দিয়ে লেখাইয়া গত 10/4/2008 তারিখে সম্পাদিত 22/4/2008 তারিখে একখানি রেজিস্ট্রিকৃত হেবা দলিল সম্পাদন করে বাদিনী বরাবর দখল পরিত্যাগ করে। মানে হু ইজ ট্রান্সফারিং? দ্য ট্রান্সফারিং is her husband, who is Alauddin.
Yes.
Now, who is Alauddin?
Mr. Rai, when did you come to know of this death?
It was issued. It was there. The date.
That the learned trial judge has placed reliance upon Supreme Court judgment. It says that this fact was available to you.
In fact, the date was not informed to any of the parties. It is the case without that before the death of Lal Mohammad, she died. This issue date, this document was issued on 10th September 2024.
That is, you have got that. It does not mean that it was not all. Is it your case that the date of 88 was registered on 2004? No.
No.
So you have got this copy of
It was
this.
updated subject is 2004.
You have got this death certificate.
Date of registration 10/9/2024.
This application.
10/9/2024. Malkali consider who have applied for registration. It cannot be registered. My lord's judgment is there. The registration is not ipso facto. If there is any doubt in the registration, then that document is subject matter of trial and somebody, because it appears, my lord.
That you have not challenged here.
So I am relying upon this.
Yes.
So that is why the document which was not there at the time of trial, my lord, or adducing evidence, subsequently I obtained.
Mr. Rai, this finding is that kindly come
It was
to
there.
Yes.
Well,
This evidence, where the evidence now sought was available when the affidavit evidence was prepared and affirmed.
Was there for a moment whether it was
not a subsequent fact which has come to know?
Not the fact.
Because you are all along aware of the fact that he died.
Yes, for the purpose of this document was not available to me. This document was not available to me.
That is up to you. You have procured. It's not that, Mr. Rai, your case is not that this date was registered in September 2024. That
Yes,
is not your
date of registration is 2024. 10/9/2024.
What do you find?
Certificate number 1, 2, 3, 4. 4 line from the bottom. 4th column. Date of registration. Well, this.
When did you? Yes, I have seen that. Date of issue and updated on.
No, date of registration.
Where?
This portion, your lordship find.
Date of registration, certificate number, date of registration. When did you give your evidence?
Prior to that, my lord. It is not a case that evidence.
No, but this is the finding of the learned trial judge.
Yes, that is the purpose finding.
Show me when did you find your...
Order 18 rule for it.
And where is your application for recalling?
Yes.
So you must have stated this is the purpose, whatever the
Yes, I have also given.
Where is that?
Can you turn to page 24?
Ma'am, death certificate khani jahan
These two questions I want to put.
And when did you file your affidavit in chief? Yes. You are PW?
1.
When was it filed?
এখানে দেখ কোথাও আছে কিনা ডেটটা নালে যশোর
Because this application was filed on 20th of November.
Yes.
At the time of PW4.
At the time of PW4.
You are PW4?
I am PW1. This application was filed
after PW4.
PW4.
Can you give me the date?
Yes, my lord. And the objection, my lord, your lordship find there is no denial that it was there. Existence of the document was there at that point of time.
Lordship, this is section 24 application for transfer the suit from Lordship Tehotto to Krishnanagar Lordship.
From?
Tehotto to Krishnanagar Lordship within the district Lordship.
Apply before the learned district judge.
Yes, Lordship, but the section 24 High Court has the power to.
Mr. Sanal, within the district judge will be in a
district
better
judge has the
position.
administrative power Lordship, but
Administrative power, it may not even require notice to be served. So I think that will be better. I'm giving you liberty to file.
Lordship, this is my application. Wife is the petitioner before your Lordship. It's a peculiar point. Wife filed an application for maintenance under section 24 in a matrimonial suit. An interim order was passed. That was ex parte. Subsequently, the husband came and filed an application under Order 9, Rule 13. And the learned trial court allowed it. Against that order, I have come up before your Lordship.
So it was, if it was ex parte, the
Interim
maybe
order,
order
Lordship.
nine, Rule 13 may not have been the.
I can show that husband was well aware of the order because on the same day the matrimonial date was also there and the husband
You
appeared
are
in
for the wife. So contested, I think it's better if I direct. Otherwise, here it will be kept.
Why I am
pending.
saying, Lordship,
I appreciate that.
I kindly allow me
You
one
want
thing.
maintenance because for this it will be kept pending before
No,
this.
no, I am not. Lord. I got an order after going through in the month of February 24.
Yes.
The husband came in the.
I'm directing this miscase to be disposed of expeditiously.
Miscase has already been disposed of.
Thereafter, it has been set aside.
There is a set aside and original miscase has been
restored.
Restored.
So I'm directing that because if their allegation was that they were not given an
Patent
opportunity.
jurisdiction of the order itself is wrong. So that is why I have come up before your Lordship. Because if this is order, it's allowed to stand, then this kind of order will be there in every matrimonial suit. An interim order of maintenance being set aside after a period of 1 year when I have filed an
If you
execution.
want, I can direct you to serve.
As your Lordship.
What do you want?
Direct the learned court to dispose of my application within a month.
After some argument, the learned advocate appeared Yes, Mr. Sannal, what is this?
Injunction, I'm late by lordship.
Injunction refused. Preemption proceedings.
Yes.
In spite of holding, my lord, can you turn to the last pro-
What is the injunction you sought for? Who are you?
I am the preemptor.
You are the preemptor. Yes. What injunction you seek?
I seek not to change the nature and character.
Mr. Rai, everything will vest upon you. Let them construct. That is the law. Entire thing will vest upon you. How are you?
If you logically consider the
Let them construct, let them improve. You will get everything without paying anything.
And not to, and because my lord, this is a co-shares property, is unpartitioned property. They have transferred the stranger into the. Now, if it is changing the nature and character, entire thing will go.
Character, everything you will get. Everything will vest in you.
Wasting a particular area, my lord, or like that.
Everything.
So
They will not take back.
And so
Whatever.
only 30 acres that I am entitled to.
I asked you what you said.
That
Nature
this is
Now you are saying not to transfer.
And the position. Man can turn to what is the reason?
Sir, it's in their possession, Mr. Rai.
No, that is entire thing depends upon that. Our case is that that is why the not to create a third party interest.
Not to create any third
because
party
that is predominantly that should be the prayer. That should be the prayer.
What should be the prayer?
Not to create a third party interest.
That is not the prayer.
But
so I will give you liberty to file an
Our,
appropriate application. Yes.
But Malad can mold the relief. If the ingredients are there, Malad can mold the relief.
No ingredient is there.
Malad can consider why the child got rejected by application.
Sir, this prayer was not there.
Malad can consider child got rejected by application. I could not understand.
On what ground?
As the basic ingredients of section 8, last portion, Malad got it.
Yes.
OP should be a stranger purchaser and the case only lie in the transfer is made to one of the co-sharers. The applicant hereby fails to make out a prima facie case in support of his right to claim by him. In view of this court, there is no bona fide dispute raised by the applicant which needs investigation, and thereby the right of the preemption be affected.
Why you have not failed to make a prima facie case?
I do not know. It is my case that I am a co-owner of the property. They purchased the property according to the stranger purchaser. Now they have said no. Previously we had the one of the co-owner by way of gift. The court is of the opinion that no scope to deal with the same before going to the stage of trial. The court
is your application for
page 20.
20.
It starts on page 18. Malad, kindly turn to page 19. Middle portion.
This prayer cannot be granted. Changing the nature is also there.
Yes, that's changing nature and character. And no entering of the case property forcible till dispose of the case.
By the order impugned, the
One more submission. I have item number 19.
19.
Yes, item number 19, Pankaj Sharaf versus Srita Bhattacharya.
What happened?
Actually, I have entered in the courtroom when just item number 20 had been taken. So I am little late because of I have another matter in another case.
Any damage caused?
Yes, I have asked him and he said that dismissed for default. That matter has been dismissed for default.
Come at 2 p.m. Onion in file ta. You have to argue.
Oh.
No adjournment. Adjournment, that order will remain.
Actually,
Yes, protocol.
Well, this is my application. Miller. If your lordship Miller takes the order, kindly have a look at the certified copy. Miller, there is a suit Miller, it's a money decree. The decree is 8 lakhs and odd Miller. However, it's a first appeal is filed before the district court. Should have been before the high court. 8 lakhs and odd is the money. That has happened. What has happened is the second appeal filed in this court. It's for fully comedy of errors. When the second appeal was being moved, it transpired before Justice Chandon Miller, being presided over by Justice, that there is a wrong recording of a wrong name in the decree in question, and the mistakes have to be rectified in the court below by filing an
He was
application.
directed to be sent down.
Yes. Now the second appeal is still there, not being admitted. Now, Miller, what had happened? We went thereafter, Miller, we went back there. Miller, trial court did not pass an order. Justice Shampa Sarkar had passed an order. We have complied with all the terms, which is at page, if your lordship kindly have a look at, the order starts at page 77 of your lordship's brief, an order of 6th of March 2024. If your lordship kindly have a look at, the entire facts is quoted there. If your lordship wants, I can place it, Miller.
Now, what is the impugned order?
Yes. Now, Miller, she had permitted Miller to carry out the rectification upon payment of cost. We have made payment of cost, and the bank guarantee for the decretal sum has also been Miller deposited with the court. Now, Miller, kindly take Miller, and we have paid a cost of 1 lakh rupees, which was imposed by the order. Kindly have a stay of 6 months. Kindly have a look at page 100, the certified copy in question.
Page 100.
Yes, kindly have a look at Miller, the certified copy, the last
copy.
page.
Yes.
Kindly have on perusal of the orders of the Honorable Court dated 6/3/2024, it is clearly appears before the court in disposing of the application will observe the decretal amount and the sum is likely to be secured. Bank guarantee has been deposited with the Register General and the same is renewed periodically in accordance with law. We have done that. Money decree. Thus, as a last stand, Honorable Court accorded 4 months' time to ECL to rectify the decree, for which ECL shall approach the trial court as well as the learned judge of the first appellate court with a prayer for necessary rectification of the judgment and decree. Within 10 days of the order, the trial judge of the first appellate court shall immediately, on the basis of the server copy of this order, the judgment debtor stroke ECL has further given liberty to file application for reconstruction of the records on the basis of the copies supplied by the petitioner. The Honorable Court has also imposed cost of rupees 1 lakh on the judgment debtor as it failed to satisfy the Honorable Court that ECL has acted diligently on 2012 onwards to cure the defects. Already leave was granted in 2012 by the Honorable Division Bench. We have also, Miller, deposited the cost. I have it, no difficulty. So, Miller, amount secured, cost deposit. Thus, the Honorable Court, by its order, directed ECL to pay the cost amount within the period of 2 weeks from the date as delay has caused agony to the decree holder. The Honorable Court has further directed that there will be an unconditional stay of the execution case for the period of 2 weeks, and the stay shall continue for a period of 7 months if the cost is paid directed by the Honorable Court. The cost shall be paid at an account pay check of such and such, the opposite party whenever it's convenient. Thereafter, decree holder is unable to obtain any stay of the division bench. Upon admission of the second execution, will proceed expeditiously. Learned advocate for the decree holder has submitted that the judgment debtor has paid the amount of rupees 1 lakh in compliance with the direction of the High Court, but 7 months period is over. So at present, there is no stay of the Honorable Court on the executing court to proceed with execution. Next page. On the other hand, the advocate of the judgment debtor submitted that the judgment debtor has already applied before this Honorable Court for rectification of the judgment and decree, and has also applied for the first appellate court for rectification of judgment and decree, but the judgment and decree has not been rectified yet. So application is on board. I have got the information that the entire records from Bardhaman has been Miller because of division Miller of Miller Purva Bardhaman and Paschim Bardhaman Miller. The matters have now been sent again back to Miller Bardhaman. So Miller, that recording I have applied within. There was a delay, not 10 days, but I have applied. I have taken steps as per the order. Kindly down. Now it appears before the court that the original records of suit case has not been received by this court from the appellate court after disposal of the first appeal. It is further appears that within the knowledge of the Honorable High Court, the records and the judgment and decree of the trial court are not available. The Honorable High Court directed the judgment letter. If the records are not available, the petitioner will be entitled to file an application for the records on the basis of the copies to be supplied. That will this copy is there, I have done. But in spite of the clear direction on the part of the High Court, the petition of the judgment letter has not been yet first appellate court for reconstruction of the record. Reconstruction of the record. On being asked about the present status of the case, the learned advocate for the judgment letter informed the court that the judgment letter has made an application for rectification of the decree, and the judgment and the learned advocate further informed that the judgment letter applied for information of the first appellate court, but no information regarding the trial court record has been provided by the first appellate court. Further, no rectification or judgment has not yet been made. But it is surprising when the Honorable High Court has given clear direction regarding reconstruction of, there was no reason for delay on the judgment letter in the case for reconstruction effort first appellate court. On the other hand, 7-month period of stay elapsed. Now there is no stay in respect of the execution. DIR has failed to take as per the direction. Decree holder has failed to take as per the express direction of the Honorable Court, not the judgment letter. In such a situation, I find no.
It should be judgment letter.
It should be judgment letter. Yeah, I find no implement proceed with the execution. The office to issue writ along with the application under order 21 rule 11 subject to payment of requisites by the decree holder. Now, my lord, if your lordship, my lord, kindly to execute the writ by appointment of a commissioner process server. Now, if your lordship takes 2 pages, page 108 and 109 of your lordship.
Why 7 months time you did not take any steps?
Look at, my lord, records going here and there. How to, that is there.
What is the mistake? Record. What is the mistake in the decree?
That is also a very nominal. Lordship can correct it here. Instead, I am going to and fro and I have secured this sum, I have paid the cost. Kindly look at page 8.
That is Mr. Ghosh lying before the Honorable Division Bench. You can pay for that before the Honorable Division Bench.
Single bench. Justice Shampa Sarkar. We went. Justice Division Bench was
second appeal, Mr. Ghosh, you could not move because there was a defect in the decree. So that is to be rectified.
I have it. Milord, the division bench, Milord, did not take up the matter. Was of the view that a revision you should apply to the trial court.
Yes.
I done that. I came before Justice Sarkar. Justice Sarkar's order is now, Milord, holding the fort. The single bench's order. That is on the basis the orders have been passed. And I have also complied with Justice Sarkar's order. I have not tried, Milord, to act, Milord. Kindly have a look at, Milord, the case, but the information slip, page 108.
What is the, show me the decree, what is the defect in the decree?
Kindly, Milord, takes page 87, Milord. 87, part of my application. Bosho, why are you standing up? Kindly have a look at, Milord, the decree in question.
Yes.
Application. I have stated.
No, application, show me the decree. Have you annexed the decree?
Yes, it's annexed.
Show me from the decree what is the mistake.
Date of the decree and Milord, the name of the judge. That's all. You can take it from.
Where is the which page?
Yes. Kindly have a look at it.
Date of the decree means it does not bear the date of the judgment.
Yes. Page 15, Lordship has kindly, Milord, takes page 15, Milord, of your Lordship.
Suppose you could have approached the Honorable Division Bench for taking
division
up.
Bench, Milord, as prayed for, Milord, it appeared before the division bench. In there, all, Milord, just division bench felt, Milord, it should be done by the court below. I go back to the court.
That is when? After that, you should have.
2012. Thereafter, Justice, I went. Again, Milord, discrepancy. Kindly look at Justice Sarkar's order, Milord. Justice Shampa Sarkar's order. In revision, I have got this. Milord, direction was passed by, Milord, the revisional court. I, Milord, comply with the decision. So, I have filed the revision.
Yes, decree is at page 35.
Decree, Milord, page 15 onwards. Kindly take page 15.
No, 36, 35, I find there is a decree in the original suit.
Type copy, Milord, Lordship is looking
type copy is 35.
35.
Yes. What is the defect in the decree?
Kindly look at, Milord, page, my junior is rightly points out, page 36. Date is wrong. 26th February 2007. It is 26th February 2006. Lordship sees, Milord, the second last paragraph.
Show me the judgment.
It's, Milord, very illegible. Starts from page 15 onwards.
It should be 26th of February 2007.
It's 2006. This is very small, Milord. Now, there is one more defect. Lordship sees it, Milord.
What is the other defect?
Other defect is in the appeal court. Because Millard confirmation, two defects, page 84, Lordship takes, this I have marked it here. Page 84. Two defects. The name of the pro forma defendant, kindly Millard, take Millard. I have stated in my petition, I am showing from the decree, Millard, which because very like unlegible.
Page.
Page 84, part of my petition.
Yes.
Name of the pro forma defendant number 5 in the trial court decree
Where
does
which
not
paragraph?
find
Yes,
place,
name of the performer defendant.
does not find in the lower appellate court, which is needed to be rectified. The name of the defendant number 2 in the trial court decree does not find in the decree in the cases of appellate court, which needed to be rectified accordingly. Appeal is at page 47, extremely Millard illegible. Millard I can show. And Millard type copy is also Millard. It said type copy is
So
also.
Ghosh, why did you wait for these 7 months?
Millard, I was doing, kindly look at, we have filed the application.
Mr.
Within
Ghosh,
7 months.
filing of the application is neither here not there.
Court was not available. I have
So
told Millard.
filing of the application, you waited for this.
That I have immediately filed. Kindly look at page 109. It's
You
secure.
serve, let them come.
Millard, kindly Millard, only the execution. Kindly Millard, page
Execution 144 is there, it can be restored.
Millard, I have secured this sum. Millard, it's lying with the registered original court side. Are you appellate side?
Could have approached earlier.
Millard, I have done.
And this order, Mr. Ghosh,
Yes.
was passed on 24th of February 2025.
Yes, this year.
Yes,
The 7 months, I have done it within 7. Kindly look at Millard, what the.
maybe Mr. Ghosh, you have filed that application within time, but you did not press for that hearing of that application before the
Millard,
last
I
trial.
tried. There was no. court
Purposely, it was kept
No,
pending
no,
for 7 months.
If I have secured this sum, what's the question of purposely, Millard? I have secured the entire decretal amount.
Because there is a
I have
clear
secured
observation, but
more
in
than
spite of clear direction of the part,
Millard, more than
has not yet applied before the first court for reconstruction of the record.
Millard, kindly look.
Where is
Millard,
the application for reconstruction of the
kindly look
records?
what the first court says.
Show me where is the application for reconstruction of
I
the
could
records.
not because of page 109. Everything gone to Bardhaman
No, you have filed an application for reconstruction. Show me that.
for rectification. Rectification. Otherwise, how do I-
Reconstruction.
how do I do it?
Mr.
Well,
Ghosh,
how do
there
I
are
do
two
it?
things. One is rectification of the
Without the
decree.
rectification, Millard, how do the records get
If
reconstructed?
Mr. Ghosh, the difficulty is that since the records are lying here and there, you are given liberty to file an application for reconstruction.
Yes, absolutely.
You could have done that. You have not filed an application for
I have
reconstruction.
done. Page 100, page 108. Kindly have a look. 108. Kindly look. On 108. This is the original case records I've asked for to reconstruct it. I have to do that, Millard.
Reconstruction will be, you have to file your own documents. Mr.
But some are
Ghosh,
missing, some are not there. If I have to reconstruct,
no, you don't have the copy of the decree.
I have the copy of the degree.
So you have to file that for reconstruction. That
But
is the
what is
only
the
thing.
date?
Mr.
I'll do
Ghosh,
it, Millard, in
what
front
is,
of
what
you.
is to be rectified is the decree.
Yes.
So you have the plaint.
Yes. Written statement.
Written statement may not be necessary
No, no.
because
Claim written statement.
no,
Appellate court
reconstruction
decree.
is rectification is only of the decree.
Yes. Correct.
So let us for the moment where from plaint will bear the full cost title,
Yes.
not the written statement. If there is any substitution made in the meantime or not, if there is so, you have to get those orders. That will form part in the trial courts. The defect is not in the trial court's
No,
decree.
no.
So defect is in the appeal court's
So
decree.
trial court decree also defect.
Trial court is with regard to the date.
The defect is in both courts.
Mr. Ghosh, there are two defects, type of
Yes.
defects. One is in the trial court's decree. The year of the
Only
year of the
2006,
decree was by mistake put in 2006 instead of 2007. Appeal court's decree, there were two defects. Some persons who have whose names found place in the trial court's decree is not appearing in the appeal court's decree. So trial court's decree, so the necessity is only to file the plaint, the judgment and the decree of the trial court, judgment and decree of the appeal court. So that you have not done.
Millard, kindly, Millard, gives me 2 minutes. Kindly take, Millard, para 12 of the last order. Kindly take page 81. Page 81, Lordship takes. Millard, 7 months you have given me, Millard. It's just over. Give me 15 days more. I'll do that before your Lordship, Millard. Where is the difficulty? And Millard, there is a compliance of your Lordship's order. Kindly take page, Millard.
No, there were two complaints. We were given liberty to file reconstruction.
No.
One is
One is, my lord,
rectification.
1 lakh cost. I have done that. No difficulty.
Cost, Mr. Ghosh, was only for the delay.
Yes.
Nothing
And my lord, no.
seems to have paid cost, but you have not complied with
No.
the application.
Second part.
Show me Justice Shortcut's order giving you
Second part,
liberty to.
if your lordship take a second part, my lord, also my lord said, my lord, for stay will be there if you secure the entire amount. I have secured the more, whatever amount she has said, my lord. The security also have furnished. My lord, a 15 days extension would have served the purpose, my lord, if at all. Lordship will kindly give me till Monday.
Mr. Ghosh, please come to page 81, paragraph 12.
Yes.
Paragraph 12.
Then, my lord, this court is informed that the records and the judgment of the learned court are not available. If the records are not available, the petitioner will be entitled to file an application for. First
So
time
you,
I
did you
asked-
do that?
Yes.
Reconstruction.
First, Miller, I asked whether the records are available or not. Kindly have a look at it. It says, Miller, it has records are available, but it is in Bardhaman this year. That is, Miller, comes up, Miller, on 25th of Miller, February 2022. Any event without going into this dispute, Miller, it has to be heard out. I am doing it, Miller, whatever said, plain written statement, 2 decrees.
Mr. Ghosh, you obtained this information
Yes.
only on 25th of February, not
Yes,
earlier.
that is,
What
Miller,
prevented you from obtaining this earlier?
Miller,
So this was after expiry of these 7 months.
no.
You waited for these 7 months.
Miller,
Then on
kindly take-
25th of February, you applied for this information.
This is already there. Do I need to construct as per page 81? This is already there.
Which is
Record
already there.
sent to DDR Bardhaman on 5/6/2017 through periodical.
Which page? Which
dispatch.
page you are placing?
Page 109. Do I need to reconstruct? If Lordship wants, I'll do it, Miller, here and now on Monday. Lordship will kindly give me limited protection. Plain written statement and 2 decree. If Lordship Miller says that is enough, we can proceed, Miller. The record sent to DDR Bardhaman on 5/6/2017 through periodical dispatch. They are also not certain.
This has been, Mr. Ghosh, this has been sent.
Yes,
So
record.
this was on, and
Yes, and
so
this
this
there.
is,
I need not reconstruct the record, Miller.
but the 108.
108
says not available.
Because LCR is in the appeal court, Miller. Lordship knows much better than I do, Miller. Appeal preferred LCR goes to the appellate court.
Yes, yes.
Naturally, it will not be there. Everything will be there in the appellate court. And kindly have a look at Miller. Miller, kindly have a look at the advocate's communication at page 91, Miller. Miller, naturally, this is not quite obvious, Miller. If Lordship knows better than anyone else. If there is a first appeal, second appeal, Miller, the first appellate court will have all the records.
No, the appeal court has sent these records.
Yes.
In
Records sent to
2017.
DDR Bardhaman on
In
such-
2017.
Yes, in 2017 it has been sent. And
Yes, to the
record-
trial court.
Yes. DDR Bardhaman. This is a Asansol man.
DRR, district record room.
This Bardhaman. Now, Miller, the district has bifurcated. Now, Miller, this district record room Bardhaman, but the trial court record says they don't have a record.
Yes.
Yes. So, Miller, if it's
So
reconstruction.
trial court, the trial court,
record.
no record. That
Appeal
is this, then page 81, paragraph 12 comes in.
Yes. No record.
So records are not available. You ought to have filed an application
But
for
if the records are
reconstruction.
there, the records are there before the appellate court.
Mr. Ghosh, the records were not available. So if you go on in this, nobody knows.
I give a suggestion, Miller. There is no point, Miller. No point, Miller, going this.
Why did you not file an application for reconstruction? You
Sir,
ought
I
to have
do-
filed an
Miller,
application for.
Lordship will give me limited.
File an application. No, no limited. First file an application, thereafter I will consider. Without that, nothing.
Kindly, Miller. Kindly,
Without that, Mr. Ghosh, you have delayed this.
Miller, kindly, Miller, gives me, Miller.
You have delayed this.
Miller,
Purposely, you have just obtained this information in 25th of February.
Miller,
You
kindly-
first file an application.
Miller, kindly, Miller, gives me a, Miller,
No, this is on 21st.
Miller, kindly.
This is on 21st.
2 minutes.
Today we are on.
Miller, kindly give me
Today we are on 12th.
12th.
File an application tomorrow. Come on Monday.
Miller, only in the meantime, Miller, may I say, Miller, I have
Mr. Ghosh, first show your bona fide,
I'll-
file an application for reconstruction
I-
and move before the executive,
I'll
move
do
before
that.
the trial court
I'll
first.
do that. Give me a breathing space till Monday.
What are the documents you are having with you?
Miller, I
All these documents you are having.
written statement. Lordship has said.
Yes, this
Decree-
judgment, decrees are all there. So
I'll
file an application. I'm only adjourning. I'm keeping in,
Monday. Keeps it on Monday, Miller.
you file an application,
Miller,
I'm keeping it on 19th.
Miller,
File an application, move before the executing court, before the trial court for reconstruction.
27 free আছে আমরা 17 তারিখে আছি, where is the problem? Miller, the matter, Miller, kindly, Miller, takes the order in question, also gives me a little protection, Miller.
27th of March, not 21st.
For execution report.
Yes, yes.
So he has to file report on.
Mr. Ghosh, enough is enough. You have,
Kindly, Miller,
you have successfully delayed this.
kindly give me, Miller, breathing space.
You
Miller.
file first, show your bona fide. 27th is the execution, nothing will happen.
Kindly, Miller, keeps it on Monday then.
So 7 months have long expired. How many months? I think 10 months have expired. Nothing has happened. Nothing will happen.
Miller, kindly.
You be rest assured, nothing will happen. File an application tomorrow. Move before the court below for reconstruction.
Miller, kindly, Miller, I'll do it here. Why send me back? I bring all the papers.
No, no, here it cannot be reconstructed, Mr.
I bring the papers here. Again, Miller.
No, no, no. Reconstruction not from here, from there. File an application for reconstruction.
But you will keep you on Tuesday, will it?
Wednesday. Ashun. been done by now.
Sir, I'll come back.
It's not that I was under the impression that the court was no. You informed it's not available. On the basis of that, reconstruction prayer was allowed then and there. You are given liberty to file an application, but you chose to file some other application.
I'll definitely. Grateful.
Yes, next.
Hi.
Yes, Mr. Banerjee.
To participate in a sale proceeding that was undertaken by the recovery officer. But there I was held ineligible without any basis. He writes that certain documents were not given. I don't want to trouble your lordship whether it was given or not. Immediately on the next day, I give all the documents. On the 4th, he receives it. On the 5th, he holds the bid and he's found somebody as a successful bidder. It is not a case where I have not deposited the earnest money deposit. I have shown my bona fides. Approximately, the bid is of 54 crores. I have put in 5.5 crores. 5.5 crores of earnest money deposit given. All I pray for, the sales certificate has not been issued. If your lordship deems fit, I will serve notice, come back. I've served everybody. No, I've not, no one was on caveat. But till that day, lordship will stay them from at least accepting the remaining of the money. I've made the successful bidder also party. I can have
the date for deposit of the money.
Well, within 15 days, sales certificate will be issued on 20th of March. But if they deposit the money in the meantime, then it will be over. 19th March. 19th March, they'll deposit it. So for some time, your lordship will give me a breathing space. I can have an open auction in court. I can do it here. I can do it before the recovery officer. If the real objective is to get more money, then he should just allow me to participate. None of the other bidders.
Why you are allowed to participate?
Well, threshold, I was not considered. Saying the documents that you've given are not correct. This he writes on 5th.
On not an appellable order, Mr. Banerjee.
I'm sorry, Milan.
Is it not an appellable order?
It is. Under section 30, it is an appealable order. So, but here, Milan, the appeal really will not. The alternative remedy, that LK Ratna
surfacing.
Not surfacing. Thankfully, this is not surfacing. This is DRT Act of 1993. This is not surfacing. Surfacing, your lordship judgment is there. I had lost, so I would not have.
DRT also judgment similar deals with public money. Objective
because it is public money. I'm before
it was in a surfacing, but it says while dealing with the public money, court should be very slow.
Which is exactly why I'm before a constitutional court. That if it's about public money, it should fetch the highest value.
Our Supreme Court is deprecating. Don't interfere under Article 226 and 226.
I am not. I am not
even taking note of those exceptions.
This is
even
not
taking note of those exceptions under which
aware of the
remedies of appeal is not an absolute bar. Even taking note of that.
But this is not a case, where a borrower has come before your lordship. I want to participate. I want to, and I'm aware of what the bidding is happening. Nobody. This is absolutely a got-up bidding that's going on. Lordship will call the parties here. I'll have the bidding in court. It'll take 5 minutes, or I can do it before the recovery officer anywhere. 5 minutes. The bidding can happen. It's public property. If it fetches higher money, and your lordship
the provision of appeal, the question of whether the court will exercise its discretion or not.
Well, I will probably be able to show that this is ex facie without jurisdiction. His tender terms and conditions don't make this an essential condition.
Those points can be raised in the appeal also.
It can be. Primarily why we had come up here was because till this Monday, the learned presiding officer of the recovery and Tribunal 1 was not there.
So now
he's there. But by the time, I don't know if your lordship is aware, but most members of the bar from this side know what's happening in DRT. It's impossible to get a matter heard. If your lordship sends me back, gives me that limited protection and sends me back, directs the debt recovery tribunal, if I file it.
Which bank is involved?
This is.
Where is its office?
This is rare asset reconstruction private limited.
Successful bidder also you have impleaded.
Yes, yes. I have nothing to hide. Everybody who participated have impleaded because the objective was that I'll do it in court.
17th I am keeping serve and come.
In the meantime, kindly rest.
19th.
So the moment I serve, they'll put in the money. documents.
As prayed for by Mr. Banerjee, learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary. When you will file the supplementary?
On
affidavit?
Monday itself.
Then service, they will be without this supplementary affidavit then. Can you serve an advance copy of that?
I'll do that. I'll do that. I'll
Uh,
serve an advance copy on the.
As prayed for.
I'll serve.
Mr. Banerjee, the point of maintainability I have said is kept open.
Malad, may I kindly mention one matter, Malad? Malad, my action was 19, Malad.
You did not appear when at 2 p.m. 2 p.m. No, nobody was there.
Coming from DRT, actually, that's why I am so late.
Somebody mentioned saying I asked her to appear at 2. She did not come.
Sir, Malad, I am coming.
NHN file ta. Yes.
Malad, actually, problem is that, Malad, service is not completed, Malad. Upon the
What service is not completed? Caveator. All right, let me see what is the matter, whether the service is at all necessary or
Yes,
not.
my lord, service, caveator is there, my lord. Caveator is
Yes,
there.
yes, let me see. What is the impugned order?
Yes, my lord. Kindly see, my lord. Rejectment.
Yes, madam, move the application. Service upon the caveator is not necessary. Yes.
My lord, I was filed section 5 application on Alipur Larnet Junior Division Court. But my lord, Alipur Larnet judge, my section 5 application not
In connection with?
In connection with this matter, Mr. Sunita.
7-2.
Yes, my lord, 7-2 petition.
Yes. Ashun.
My application, my lord. No, my lord, in this proceedings, my lord, an application for grant of probate was taken out by the petitioner before the learned court below. My lord, once thereafter, my lord, it was discovered that the last abode, my lord, of the deceased testator, my lord, was within the jurisdiction of the learned city civil court. Now, my lord, at that juncture, there was an application taken out in terms of, my lord, Order 7, Rule 11, Order 7, Rule 10, my lord, seeking for withdrawal of the proceedings. My lord, at that juncture, the learned district delegate, while returning the application, has returned only the cause papers, whereas the will had been transmitted to the learned district judge in terms of section Rule 305, my lord, of the civil rules and orders. Now, my lord, the contention before your lordship is that Rule 305 of the civil rules and orders, my lord, applies only in the event where the grant of probate has been made in respect of a will. That is when the original will is sent to the learned district judge. In the present case, my lord,
which order you are challenging?
my lord, there are two orders which I am challenging before your lordship, my lord. One is
2023.
2023.
So, what is your explanation for the delay?
That I have explained.
What is your explanation? I'm asking you.
My lord, the delay because, my lord, I had lastly applied before the learned court below sometime, my lord, on 18th of July 2024.
For?
My lord, seeking for withdrawal of the will so that I can, my lord, file it before the
No, you are
appropriate court.
challenging the earlier order of June 2023.
June 2023. But my lord,
So-
during the interregnum, I did not have the right kind of approach, my lord, so that I could, because the application itself, my lord, was returned. So I could not have taken out an application. Once it was filed, this was repeatedly the order which was being passed by the learned court below. That since the matter has been transferred to the learned, since the will has been sent back to the learned district judge and the matter stands disposed of in terms of Order 7, Rule 10, nothing remains.
Where is the order passed under Order 7, Rule 10?
Yes, my lord. That your lordship
That
will
is
find
31st of January.
31st of January 2023. Your lordship will find that at page 18 of my application. That's there at page 14 also. 18 and 8. No,
Show me Rule 305.
একটা copy না
by order না না, আগেরটা কেটে দিন, এইটা থাকবে।
My lord, this is my application. I am the defendant in the court below in an eviction suit. That suit was dismissed for default. The plaintiffs applied under Order 9, Rule 9 for restoration of the suit. That was allowed. I am challenging that order, Your Lordship.
Order 9, Rule 9, you are challenging.
My Lordship, my twofold submission is that there is no finding on the fact that there is sufficient cause shown by the plaintiffs. If Your Lordship kindly takes up the impugned order, rather the findings arrived at is to my benefit. If Your Lordship kindly takes up the second page of the impugned order, Your Lordship. The learned court is bound to make a finding regarding the sufficient cause shown by the plaintiffs.
This was a dismissal under Rule 8.
Rule 8. Yes, the defendant appeared, plaintiff did not appear. So they applied under Order 9, Rule 9. Now, there is no clear finding. Your Lordship kindly takes up the second page, second paragraph, Your Lordship.
Of the impugned order.
Of the impugned order. If I may kindly read from the third line. That accordingly, keeping in mind the previous conduct of the plaintiffs, which he seemed to be reluctant, the suit was dismissed for default. During the course of hearing, learned advocate for the opposite party pointed out that the previous conduct of the petitioners, but this court is of the opinion that while dealing with a miscase under Order 9, Rule 9, the court will only take into account the former conduct of the petitioners prior to the dismissal order.
You want the cost to be enhanced?
Your Lordship,
you want the cost to be enhanced?
Because
that is your real grievance.
No, Your Lordship, my submission is that it's kindly sees the findings, Your Lordship, kindly sees the findings that the same appears to be unsatisfactory. The court records this. Thereafter, admittedly, it can be presumed that there has been a misposting on behalf of the learned advocate for the petitioners. This is their ground, but the learned court did not consider the evidence. The learned court is presuming that there has been misposting on the ground of the learned advocate. But in order to prove the same, no scrap of paper has been filed by the petitioners. The learned court also records this, that the advocate's diary has not been filed. The learned advocate did not file any affidavit or gave any oral evidence. There is no, they have not shown any sufficient cause, but for the ends of justice under 151, this application has been allowed, Your Lordship.
Cost has been paid.
The cost, we have not accepted the costs.
Tendered.
It was tendered, we have not accepted the cost.
This application under Article 227 of the Constitution of India
I'm from the petitioner, my lord. My lord, last annexure is the impugned order, my lord.
Yes.
My lord, the title suit was dismissed, my lord, after trial. On the
Title
ground,
suit was dismissed after trial. Yes, what happened thereafter?
the merely
You are the,
I'm the plaintiff.
yes,
So mainly on the ground of non-joinder of parties.
non-joiner of necessary party.
Necessary party
That is a good ground for dismissal of a suit.
of the suit. Well, I have preferred an appeal along with the order. It is curable defects, my lord. This defect is curable. I have filed an application along with the appeal, order 1, rule 10, 2. My elder brother has not been party. I have not.
What was the suit for?
Suit for declaration only. Suit for declaration and
What was the
injunction.
declaration sought for?
So I am the absolute owner in respect of the. I am the owner in respect of 28 of decimal of land. Out of 19 decimal of land, out of 18 decimal of land. Will you kindly see the last annexure, my lord?
Give me a minute.
Well, nobody will be prejudiced, my lord, if in the appeal court, the my learned, my junior, junior brother may be impleaded as party for the interest of the justice, my lord. Well, Lord, I have cited, my lord, one judgment. Then the appeal court, order 1, rule 10(2) may be allowed for the proper adjudication.
Is your answer to section 99 of the Code of Civil Procedure? Section 99 of the Code of Civil Procedure.
Section 99.
Yes, yes. এটা দিয়ে দিন তো।
দেখে একবার।
Left hand side top.
হ্যাঁ। No decree to be reserved or modified. Reverse or modified for error or irregularity not affecting merits or jurisdiction. No decree shall be reversed or substantially.
Thereafter.
Reverse or
nothing in this section shall apply to. Read that.
The name. No degree, whatever the 90 section is there, I am reading.
Thereafter, nothing in this section, you have not completed.
Provided that nothing in this section shall apply to non-joinder of a necessary party.
So your case is that he was a necessary party, so it cannot be reversed. So addition cannot be done. Even if
it is the law. It is the only law, the statutory law. My lord, Supreme Court judgment is also law. My lord, one AIR, my lord, 2005 Supreme Court cases. My lord, in appeal court, the proper adjudication of the case, my lord, it can be allowed. My lord. Nobody will be hard. Let it be tried. After calling there is one necessary party is lost at that time, he may be added.
This is order 22, rule 10. Which paragraph you are relying upon? Of which judgment? You have given me 2 copies.
2 copies, 1 copy.
Marked copy will help you.
No. Yes, I have started.
All right. Yes, take it. Which paragraph?
My lord, paragraph 1 to last from the bottom.
Paragraph.
Procedural code.
Paragraph. Which paragraph?
Order 1, rule 10(2).
Which paragraph you are placing the head note?
No, not placing.
What paragraph?
What I think portion, my lord.
Which paragraph?
I am telling you, the 1, 2, 3 in the inner page, my lord, page 3. The object of order 1, rule 10, order 1, rule 10(2) is to discourage contest on technical pleas and to save.
Sir, which page you are placing? There is a page number.
Page number 405.
Top left hand column.
405.
Top 405. Yes. The object of, yes.
Order 1, rule 10 is to discourage contest on technical pleas and to save honest and bona fide claimants from being non-suited. The power to strike out or to add parties can be exercised by the court at any stage of the proceeding. This is the essence of the order.
Yes.
Paragraph 406, Miller.
Page 406, yes.
In the bottom, Miller, the serial number 3, whether the High Court has not committed serious error while concluding that the presence of the appellants is not necessary in order to decide the appeal and there is no merits in the application for addition of party through the application was made by the appellants for substitution or other names in the place. Still contesting defendant number 3, who sold the property. This is the my lord, the facts of the case. My lord, kindly 409, my lord, once more.
409, yes.
My lord, serial number 9. Middle portion of the page. The object of the order 1 rule 10 is to discuss contest on technical fees and to save honest and bona fides from the being non-suited. The power to strike out to add parties can be exercised by the court at any stage of proceeding under this rule. A person may be added. My lord, thereafter, my lord, paragraph number 11. Bottom portion, my lord, paragraph number 11, last bottom, 1, 2, 3, 4 lines from the bottom.
Yes.
Both the appeals were heard and by a common judgment and order dated 25th, 1992. The said appeals were allowed and the judgment and decree passed by the Munsif was set aside by a deed of assignment such and such and such. Last portion, my lord.
You will not read that portion. Please read it loudly. That assignment, that portion, you skip that, but it is of relevance.
Observation, last line, my lord, page 4, 11. 411.
409, last 3 lines you will not place.
This is not helpful, my lord.
That is not relevant. Yes. Next.
Page 411. 411, last portion.
411.
411.
Yes.
Therefore,
Paragraph.
the appellants who are transferring pending.
Which paragraph?
Paragraph EFG. Last portion.
Paragraph?
Paragraph EFG. Paragraph 17.
Paragraph 17, yes.
Therefore, the appellants who are transferring pending rights should be made as parties to the pending second appeals as prayed for them. In our opinion, the High Court has committed serious
The
error.
person whom you are seeking to add a transfer pending here.
Here, my lord,
In this matter.
This is,
in this case, their transfer is pending.
But facts of the, my lord, the essence of the case,
Yes.
the ratio,
Give me a minute, let me go through the impugned order.
Last order. The ratio decidency is taken up, my lord. If one party may be added, then nobody will be prejudiced, my lord. Your lordship's intervention is necessary in order to conduct the appeal regularly.
Whom do you want to add?
My junior, my younger brother, who has not been party at the.
What is his name?
Is Muhammad Amin, Muhammad Ruhul Amin. Muhammad Ruhul Amin. It was wrongly written Ruhul Amit. Both are the same person, my lord. If he may be the added party in the appeal also, my lord.
Where is the judgment of the trial court?
Yes, well, I have annexed.
Page,
My lord. The judgment is, my lord, page, my lord, 8. I have annexed the
they
judgment
show
of
me that portion with regard to,
rule, I mean.
yes.
Yes, my lord. Yes, my lord. Yes, my lord. My lord, paragraph, page number 29, my lord. There is one portion. Page number 29.
Anything more?
No, page number 29, my lord, relevant paragraph.
Yes, I've seen page number 29, last portion of,
First portion also, first portion.
yes, page
Exhibit-
28, page 28,
29,
last paragraph, page 29,
20,
first paragraph.
upper portion.
Yes, I've seen that.
Therefore, this court is on the view that the rule.
I've marked that
Yes,
portion.
carefully.
This application under Article 227 of the Constitution.
15, you'll have to fix the matter.
315. Yes,
Item number 70,
70. Yes, Mr. Mitro.
Suit filed, my lord, ex parte application moved. My lord, no interim order was passed, my lord, no ad interim order was passed. And my lord, the order is a very reasonable order. Obviously, I will say. Now, my lord, they had preferred an appeal. The appellate court, my lord, has.
According to you, the trial court's order refusing was a reasoned order.
The order will,
They preferred an appeal.
the order will speak for itself, my lord, according
What has been done, stayed.
Till 19th, Lord, the injunction was granted on our prayer. Declaring, Lord, that East Bengal Club will not be, Lord.
Thereafter, injunction was granted.
I will show your lordship, my lord, the plaintiff on the face of it, the plaintiff.
It cannot be stayed, Mr. Mitro. It has to be hard
And, Lord, the
final.
injunction is fixed on, Lord, the 19th.
Yes.
The learned judge says that, Lord, it is written
Injunction
19th
before-
March, 19th March.
before the trial court.
No, no.
Before the appeal court. First appeal court.
Injunction of the miscellaneous appeal itself.
Injunction.
Has to be injunction.
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 ও, তুমি আবার কোথায়?
Yes, Mr.
জলপাইগুড়ি।
Visible, Mr. Chatterjee.
Milord, I am, my video is
audible.
not functioning, Milord.
Possibly not in a position to make himself, my lord, visible.
Milord, the video is not working, Milord.
Yes.
But I really, my lord, cannot finish in 5 minutes. Can I come back tomorrow or, my lord, on?
Tomorrow, 2 p.m., Mr. Mitro.
No, no.
But your lordship takes it up next week, Lord, any day. Tuesday or
Tuesday, my lord, in that event.
Mr. Mitro, if 19
or
has been
Wednesday.
fixed,
Kindly take it
this
up.
was the added trip. Let it be decided.
Kindly take it up on Tuesday. Lordship will decide that on Tuesday.
Tuesday is the difficult because that is the combined listing. That is the difficulty. So it can come on 19th.
But in the meantime, Lord, may I use a supplementary affidavit,
Oh,
Lord, to
Baba.
show the subsequent event, what had happened. Even the IFM, Lord, the meeting by which, Lord, they have to decide on, Lord, the fate of the, Lord, the
Whether that subsequent event, Mr. Mukherjee, can be
But that
taken
might
note of.
I will show you, lordship, my lord. On the face of it, the plaintiff does not disclose any cause of action. On the face of it. They have obtained order against East Bengal Club, my lord. I was told many things by Mr. Chatterjee about that. Effect is, my lord, East Bengal Club cannot, my lord.
And Mr. Chatterjee is appearing, Lord, to defend, Lord, East Bengal Club now.
No, I am against, completely
Club.
against.
IFA and Diamond Harbour Football Club
Effect is, my lord, kindly see the prayers. The
in the
effect,
plaint.
yes, yes.
Mr. Mukherjee, I am appearing with you.
My lord,
I'm so sorry. That's the reason.
kindly come to page 152, my lord. The suit has been.
So it appears that Mr. Mukherjee and Mr. Chatterjee did not hold previous conference prior to this. Because
No.
It's difficult for my
who
lord.
are appearing for whom?
It's difficult for my lord, two very busy persons to, my lord, find out.
But there are two more even busier persons above us.
152, yes.
Now kindly come to
Oh, yes. I've seen the name.
This is not a party event in the suit. Forgetting about that, my lord, their case was, my lord, that reschedule. My lord, I will show your lordship, my lord, from the plaintiff itself that, my lord, no rescheduling was required.
Mr. Mitro, Wednesday. Let it be hard. There is no difficulty.
Kindly.
If
Then
it is not
can I come back on Monday, my lord?
Wednesday,
I know your lordship's difficulty, but
that is
kindly.
the only
I do
thing.
not say like this, my lord. Kindly come back.
Because this Mr. Mitro cannot be disposed of.
If I cannot, my lord, if I take more than 15 minutes time, my lord, lordship will kindly send it back. I'll finish it in 15 minutes. I will show your lordship, my lord, from the plaint itself, from the documents disclosed by them, it would be evident
Because
that
the only difficulty is this, today there are some backlog motions. Tomorrow also there will be some, that is the difficulty. So Monday maybe possibly one full day for motions of the supplement. That is the only difficulty. No, your junior is nodding his head. So Monday
I know.
also
No,
the,
Monday morning, my lord, possibly there.
so then the entire day will not be. So let it be on Wednesday. Because the motions, Mr. Mitra, has to be given precedence. You do not know in the morning, Mr. Chatterjee was online. What was the rush for mentioning for upgradation as for enlistment?
Well,
So that-
hopefully, beloved, those mentioning are all mentionings are
Chatterjee
allowed.
is also party to that prayer for upgradation. So
Economic
Chatterjee was also,
don't hear him.
was
Arey,
also a party to that prayer.
Millard,
For,
now Mr. Mitra is supporting East Bengal. Millard, he is saying things against a Mohun Bagan supporter.
Can I come back on Tuesday at 3 p.m., my lord? Or at 3
then,
p.m.?
then the monthly list will be getting, that is the only one day I'm taking up the monthly list. Because upgradations from the Monday, Mr. Mukherjee, junior Mr. Mukherjee, why are you nodding your head? Something there in Monday?
Something brewing, I believe.
Somebody else is also being elevated.
Vinaki.
Prabhu.
Recording will help all of you, I think. Mr. Mitchell, honest senior advocate appearing for the petitioner, commences his argument. তার আগে লিখুন, gives a brief outline of the issues involved in this civil revision application. However, Mr. Mitra could not conclude due to paucity of time. Mr. List this matter.
Can I come back at 11 on Wednesday, my lord?
11. 11, it's difficult. All motions will get stuck.
But may I file a supplement?
My request to all of you.
3 p.m. 3 p.m. on
Wednesday.
Yes.
Wednesday 3:15, say.
Lordship, sir. Yes.
Wednesday 3.
Grateful to your lordship.